you very much, Michael. Let me just say some thank yous. First off, to start, I want to thank Craig Flood for Koski-Minsky for his kind words last night, but also just collaborating with what used to be Heenan Blakey, now Fasken Martineau, on putting together this event with Michael, which has been a pleasure, and it's a great moment every year, actually, when we hold these events. I want to thank the Dean Chamberlain, for hosting this event. It's this sort of event, I think, that distinguishes a law school like the one at Western Law. Let me say this about Michael. Within every community, there's always leaders. And those leaders tend to possess kind of intelligence, vision, dedication. And Michael Link is a leader in the Canadian human rights community. And his reputation, his integrity, and his influence, they extend far beyond our Canadian borders. So I thank you for working with us. It's always a pleasure and an honor to continue with this collaboration with Koski-Minsky and with Michael. I also want to acknowledge, in terms of this year's conference, the effort and work that's gone into this by both John Craig of Fasken Martineau, who I work with, and Michael. So, before descending into the conference that will explore in depth the current Canadian experience in relation to the workplace, let me make some introductory remarks aimed at situating the unfolding Canadian experience within the broader international developments shaping the global workplace. That will be the task I'll take on today. The Canadian experience is tethered to international developments. As such, the global helps understand and interpret the local, if you will. I will focus my remarks, therefore, on highlighting the leading trends, initiatives, and developments at the international level with respect to the world of work. But first, let me take stock of where we seem to be at in terms of globalization, which, as you know from Professor Weil's outstanding book and presentation last night, has been fueled by technological innovation. Before the 2008 financial crisis, global trade grew at as much as double the rate of global output, global GDP. And this is data drawn from the World Economic Forum, by the way. Since 2011, trade growth has slowed to be in line with or even less than the broader growth of the global economy. In 2015, global trade grew at about 80% as fast as the global economy, the first reversal of globalization since 2001, and only the second since 1982. A few reasons have been advanced for this decline in economic globalization. The first is the recession of 2008, which the world economy is still climbing out of. The second is protectionism, which is on the rise. The World Trade Organization, in a July 2016 report, indicates that members of the WTO have put in place more than 2,100 new restrictions on trade since 2008. As we dig a little deeper into why, we look at multinational corporations. And there has been a noticeable shift from globalization to localization. This has produced a different global footprint, marked by a narrowing of the MNC's international presence and a reinforcing of the MNC's focus on their home markets. Globalization is also becoming a digitalized phenomenon. The volume of cross-border data flows has soared 45-fold since 2005, and it is expected to grow another 9-fold over the next 5 years. Digital platforms like Amazon and Alibaba enable even small-scale entrepreneurs to connect directly with customers and suppliers around the world, transforming them into micro multinationals. And then there are the political developments of late. And this is the most obvious break on globalization. Economic globalization, with its social disruption, has caused a political backlash in advanced economies, in the developed world, if you will. Today, multinational corporations are viewed as agents of inequality. As globalization and multinational corporations have narrowed inequality among countries, at the same time it has aggravated income inequalities within them. So if I look at the decade 1998 to 2008, as incomes rose significantly for most of the world's population, an examination of the experience in advanced economies tells quite a different story of winners and losers. The middle class in advanced economies from 1998 to 2008 experienced no income growth. In fact, after 2008, it only got worse. In the same period of time, income soared by nearly 70% for those at the top of the global income distribution. And so, in the regions and industries hit hardest by import competition, the growing social discontent translated into support for populists promising to reverse globalization. The evidence of this new political reality is everywhere. Think of Brexit. Think of the election of Donald Trump just 1 year ago, believe it or not. Seems like longer. Whose base includes those adversely affected by the status quo. No less an authority than Larry Summers, former Secretary of the Treasury in the Clinton administration and Director of the White House National Economic Council in the Obama administration, and a strong proponent of economic globalization. By 2014 and 15, he was complaining about the development of stateless elites whose allegiance to global economic success and their own prosperity rather than the interests of the nation where they are headquartered. By 2016, he was warning that the public's tolerance for expert solutions appears to have been exhausted. He advised a new, quote, responsible nationalism, unquote, which would begin from the idea that the basic responsibility of government is to maximize the welfare of its citizens and not to pursue some abstract concept of the global good. And so this is a snapshot of the state of the world we live in today. It's quite a polarized world without a stable center. On the one hand, you have the forces of anti-globalization. On the other, you have those in favor of reforming globalization. And in that category, there are many national governments in advanced economies. Germany, France, Canada come immediately to mind. Having just witnessed Brexit and the election of Donald Trump and its fallout, and wishing to avoid the same fate, and they are firmly within the Reformation column. So, the question becomes, how do you reform globalization? Since before the turn of the century, the international community has identified a social deficit embedded in globalization. Really happened in 1996 at the WTO Ministerial Conference in Singapore, where it became official. Although considerable efforts have been made since that time to reduce or eliminate the social deficit, those efforts of late have become intensified. There is now underway a determined effort to enhance the social dimension of globalization. These efforts that I will canvass next are aimed at reducing, if not eliminating, the social deficit, and in so doing, finding a balance between economic development and social progress. The belief being that with balance, that is, a wider dispersal of the fruits of globalization, comes sustainability and a new center that will hold. Let me now turn to a review of the activity on the international stage aimed at repairing the social dimension of globalization. This conference will descend into the domestic in the same regard. And by the way, my preceding comments were intended in large part to animate the catalog that follows. So, the centerpiece of the global human rights movement is the United Nations Guiding Principles on Business and Human Rights, the UNGP, enacted in 2011. The UNGP, which incorporates the ILO's Fundamental Declaration from 1998, which houses the core global labor standards: no forced labor, no child labor, no discrimination in employment or discrimination, freedom of association, and the right to effective collective bargaining. This is the work of Professor John Ruggie. And he constructed the three-legged stool, which we're all familiar with. The state's duty to protect, business's duty to respect, and access to effective remedy. In the last 5 years, there has been a dedicated effort to operationalize the UNGP. This effort has swept in all parties, supranational organizations, national governments, and at the level of civil society, NGOs, the trade union movement, particularly global union federations, and multinational corporations. There is a ton of work left to be done. The question now for you is, and what has or is in the process of being produced? Let's break it down into the different groups that I listed above, and I'll start with supranational organizations and national governments. And in this regard, I'm going to talk about 4 developments. There are others, but I've selected these 4 that I think are noteworthy. And I'm going to start with the UN Treaty on Business and Human Rights. An intergovernmental working group was created by the UN Human Rights Council in 2014 to draft a new international legal instrument to regulate the activities of MNCs in relation to their human rights impact. The 3rd session of the working group actually took place last week in Geneva. The working group reviewed a working paper published on September 29. This is all happening as we speak, by the Ecuadorian chair of the working group. The working paper suggests that the proposed international treaty, this is taking us a little back to the 2003 effort of former Supreme Court Justice Louise Arbour, the UN draft norms. But the working paper suggested that the proposed international treaty would apply to violations of human rights, quote, resulting from any business activity that has a transnational character. That term is not defined. That will be the subject of a lot of debate. So the purported aim of such a treaty would be to clarify the legal obligations of multinational corporations as opposed to the legal obligations of ILO member states with regard to human rights. Secondly, national action plans. Increasingly, states publish national action plans on business and human rights, setting out their policies for implementing the UNGP, the centerpiece. Europe has taken the lead in relation to national action plans. Let me talk about the UK and France for a moment. First, the UK. The UK launched the first NAP in 2013, which resulted in the enactment of the Modern Slavery Act in 2015. Under the legislation, any organization that provides goods and services, generates a turnover in excess of £36 million a year, and carries on any part of its business in the UK, now has to produce an annual transparency statement, setting out the steps it has taken to ensure that slavery and human trafficking are not taking place in any part of the business or its supply chain. Turning to France. On March 27, 2017, France adopted a corporate duty of vigilance or duty of care law. The law is expected to come into effect in 2018. Essentially, the French law builds on the due diligence requirements found in the UNGP. As between the UK and the French examples, the UK law has greater reach as it focuses on annual turnover in the UK, that's the £36 million a year, as the criterion for reporting. Whereas the French law only applies to French companies and is based on the number of staff employed, 5,000 within France or 10,000 within the global operations. So it is estimated that around 150 French companies will be affected by the new law, compared to more than 13,000 in the UK. A similar legislative approach has been adopted in California and will likely soon be adopted in Australia, where public hearings have recently taken place. Canada, so far, has followed a different approach. In 2009, it adopted a CSR strategy in respect of the extractive industry, an industry Kevin Banks is very familiar with. Since its update in 2014, this now includes an expectation that Canadian extractive companies operating abroad should align their practices with international CSR guidelines, which include the UNGP. Third, access to remedy. In 2017, the third leg of John Ruggie's stool was actually being referred to as the forgotten pillar. And so a lot of effort has been dedicated in 2017, and it will extend beyond, to access to effective remedy. A working group, and here's what I'll say about that. A working group of international law specialists has recently published a proposal. And this community will be familiar with this. It's what we do writ large. They published a proposal to use arbitration to resolve disputes arising out of human rights abuses involving businesses. The proposal is that international arbitration rules and institutions be broadened to include human rights disputes involving multinational corporations, their business partners, and victims of abuse. The tailor-made process, which they refer to as the International Arbitration Tribunal on Business and Human Rights, or the Tribunal, would offer the following features. The tribunal could significantly shorten the time and cost for resolving disputes, as opposed to, for example, the court system. The parties could choose arbitrators who are independent, impartial, and have high levels of expertise related to human rights matters. The tribunal would make available as well skilled mediators, specialized in assisting in the resolution of human rights conflicts at an early stage. Hearings could take place anywhere, including even online. And finally, legal developments on business and human rights would be enhanced over time through the publication of a body of reasoned arbitration decisions. The proposal, which I just outlined, and the entire topic of access to remedy is the central theme of the upcoming 2017 UN Forum on Business and Human Rights that will take place later this month in Geneva. Finally, future of work. This is an enormous topic. Professor Weil has delved into it from the perspective of corporations brilliantly, in my view, in his book, and I thank you for that. It's an ongoing debate, and it's centered on the impact of the twin engines of globalization and technological innovation. Work, as we know, is about more than just compensation. It's about our sense of personal worth and social connections. At the international level, many organizations are attempting to delve into this critical issue. The ILO, for example, just launched the Global Commission on the Future of Work in preparations for its 2019 annual June conference in Geneva, which will center on this topic. For today, let me simply direct you to the work of one person who I find fascinating, which is Andrew Haldane, the chief economist for the Bank of England. And in particular, his speech to the Trades Union Congress in London, November 12, 2015. In that speech, Andy Haldane points the audience and reader to the following. We are on the cusp of a fourth industrial revolution, which some refer to as the second machine age. As technology becomes smarter, the greater the likelihood that the space remaining for uniquely human skills could shrink further. He refers to this as the hollowing out. To quote from Mr. Haldane's speech to the Trades Union Council, if the option of skilling up, that space now occupied by technology, is no longer available, this increases the risk of large-scale or underemployment. The wage premium for those occupying skilled positions could explode. Starting to sound familiar? Further widening wage differentials. And labor's share of the pie could fall even more dramatically than in the past. On this view, the tree could become hollowed out to the point it may no longer be able to support itself. This leads the Bank of England's chief economist to consider the public policy implications of such a trend line in the world of work, including the need to adjust the educational system away from cognitive competences, reading, writing, arithmetic, and towards non-cognitive skills possessed by humans, such as, and this list we're very familiar with, relationship building, negotiation skills, and empathy. And second, the need as a society to consider, this is fundamental, to consider redistribution of wealth as the gap between skilled and unskilled workers widens. This gap could bring pressures to reallocate income from rich to poor, from owners to workers. I don't want you to think that it's only at the level of supranational organizations and national governments that there's a lot of work being done in the reformation column of globalization. You also have civil society making efforts to improve the situation. And I want to point you to two examples involving primarily multinational corporations and global union federations. The first relates to international framework agreements, IFAs. The definition of IFAs is important. These are contractual arrangements between multinational corporations and global union federations across the jurisdictional lines of operation of the multinational corporation. So, for example, Ford Motor Company has an IFA. It doesn't just apply in the United States. It applies everywhere Ford Motor Company operates in the world. So this is the trade union movement working with multinational corporations on the global stage. There are about 100 active IFAs. The most recent generation of IFAs, and there have been 6 or 7 actually that have been negotiated in late 2016 into 2017. The most recent generation of IFAs are noteworthy in terms of expanding the accountability of corporations for their human rights footprint by extending the scope of the IFA to include the business partners of the MNC, suppliers, contractors, producers. And second, in some instances of late, transferring decisional power in respect of human rights disputes that arise between the parties to neutrals. In the case of, for example, the high water mark is an IFA involving a German retailer, Chibo, TCH-IBO. And in that IFA, negotiated in late 2016, in the event of a dispute that cannot be resolved, the ILO and its supervisory staff is called in to try and mediate a solution, and if that fails, to then issue final recommendations for the parties that are final and binding. Secondly, I was going to point you to industry and multi-stakeholder codes of conduct. And in this regard, I'd reference the Bangladesh Accord, which I'm sure we're all familiar with, which was the product of the Rana Plaza tragedy. The Bangladesh Accord is noteworthy in at least a couple of ways. First, it's an enforceable agreement between global union federations, NGOs, MNCs, and local unions in the garment industry in respect of workplace standards in those companies' supply chains. And secondly, it incorporates a strong legal adjudication mechanism in respect of disputes over the interpretation and application of the Accord agreement, including the provisions related to the social labor provisions. And what they've incorporated, in fact, is the UNCITRAL model law on international commercial arbitration, which is a well-established formal arbitration system backed up by a significant body of case law. So that's kind of an overview of what's been happening on the international level. What's Canada been doing on the international stage? So has the Liberal government, midterm, in its first term in office, has it performed in accordance with or at odds with this, I think, identifiable international effort to reform globalization? I would suggest that the federal government and a number of provincial governments have performed in a manner consistent with the identifiable international push to reform. Think for a moment about these actions by the federal government over the last couple of years. You have the ratification of CETA, the trade agreement between Canada and the EU. which was ratified, came into force late September 2017. The CETA represents a progressive social labor agenda. In the space of 25 years, we've moved from NAFTA, which we all know is now being renegotiated, with the federal government taking a progressive stand on labor issues, by the way. We've gone from NAFTA, 1994, which had a mere side deal, I think blandly addressing social issues, the North American Agreement on Labor Cooperation, useful in some ways, but quite bland, often referred to as toothless, to CETA, with very significant social labor provisions that are found in the main body of the document. Chapter 22 on trade and sustainability, Chapter 23 on trade and labor are very substantial provisions. Whereas NAFTA simply required the parties, Canada, Mexico, the United States, to adhere to whatever domestic laws were on their respective books at the time, CETA actually requires the parties to achieve and maintain international standards found in instruments like the Fundamental Declaration and the UNGP, accompanied by a European-style enforcement mechanism aimed at ensuring compliance with the provisions of CETA, including chapters 22 and 23. Further, as a part of the CETA process, Canada undertook to ratify all 8 of the core conventions that underlie the Fundamental Declaration that I've referred to earlier. In June of this year, the Federal Minister of Employment, Workforce Development and Labor, the Honorable Patty Hajdu, she attended at the annual ILO June conference, and at that conference, she ratified, on behalf of Canada, the one remaining unratified convention. We had ratified the other 7. She ratified Convention 98, the recognition of the right to effective collective bargaining. This ratification of Convention 98 represents a strengthening of the trade union movement in Canada. Domestically, the federal government has moved in a similar direction, as evidenced by, for example, the changes to the Canada Labour Code found in the 2017 federal budget, and the revival of the Arthur's Report from 2006, dealing with Part 3 of the Code, both of which are aimed at reforming workplaces in Canada. To complete the Canadian picture, it is necessary to add that a number of provincial governments, Ontario, Alberta, and British Columbia, are all in the legislative process of reforming their provincial workplaces. And all of this is the subject matter of the conference that lies before you. Armed with this contextual international perspective, let me turn the proceedings over to Professor Weil and his panel on the political economy of workplace precariousness. Thank you.